Good evening, everyone. Good evening, good evening, good evening. Christian McCray Stewart here with McCray Stewart and Associates, your trusted advocates for justice and peace of mind. We are here for yet another Wise Counsel Wednesday. So, as people are we give some time for people to come and join on. Let us go ahead and share, like, share, so that we can ensure that this information is getting out to everyone. Because as we say, sharing is caring. So as you join on to the live, go ahead and take some time just to hit the like button, to share it on your page, to send some text messages out to some individuals and let them know. We're going to have a good conversation this evening. And I think it will truly be a benefit to all who are able to join on. And, sometimes individuals don't necessarily want to ask a question, but somebody else's question could be answered and it assists them as well. So come on, join in, join in, join in. And just as I have asked you all to share, I'm going to take a second as well to go ahead and share this with people so that they do not miss out on this evening's Wise Counsel Wednesday. With that, I hope everybody is having a wonderful Wednesday. Mine has been long. I've been in mediation all day, but here I am to come and serve our wonderful clients, past, present, and future. Good evening, everyone. I'm almost done here sharing in the whole 9, and then I'm going to give you all my full and undivided attention. Okay. Look like they changed a few things up, but that's not a problem. Interesting. Okay. All right, but good evening, everyone. Good evening, good evening, good evening. So, welcome to yet another Wise Counsel Wednesday. As you all know, I am Christian McCray Stewart, and we are with McCray Stewart and Associates, your trusted advocates for justice and peace of mind. And as you all know, and for those who don't, what we have started is we come and we do these Wise Counsel Wednesdays. We have a topic that you are able to come with your questions. You can submit them ahead of time. You can come while we're live and present your questions, and we're going to provide the answers for you so that way you are equipped with the knowledge needed to proceed and to move forward. Disclaimer: answering your questions does not form an attorney-client relationship. This is not legal advice. We're providing general guidance so that way you are better equipped to navigate whatever potential legal situation or circumstances you may be facing. However, if you have more in-depth questions, you can always reach out to us to schedule a consult. We're going to be more than happy to assist you and to help you. Okay, because our motto is we are concerned about you as an individual. Yes, you have a legal matter. Yes, it needs to be addressed. But overall, we want to make sure that you are in a good place and that you're able to navigate this. And guess what? You don't have to do it alone. We will do it with you. With that being said, our topic for this evening is clearing your record. What you should know about expunction. Expungement. Also, in certain states, they may have what they refer to as non-disclosures, but that's what we're going to be discussing. So I have questions that have been submitted prior to time that I am going to address. And as you all know, if you have a question while we're live, throw it in the chat. We're going to make sure that it's answered. Okay. So we are about to jump into it, our live Q&A. Live Q&A time. So let us remove this and let's get ready to get into it. Okay, so for a broad overview, when we're talking about expunctions, expungement, what that is a avenue for you to be able to clear your record. So if you've been arrested, charged with something, in certain situations, you are able to have that record removed as though it never happened, which is a plus for a lot of people. Think about juveniles who may have been charged with something in their youth. You don't want that following you around, especially and typically where you see this come up a lot, where people are concerned about those in certain situations when they're trying to go out to the military. Because the one thing about it is, like, in most states, if not all, juvenile records are sealed, right? They're not accessible to the public. However, the military can get any and everything. So even if you have a juvenile record, the military can access it. And so a lot of people, in light of that, they move to take the necessary steps to make sure that those records have been removed as well, especially if they're aspiring to join the military. Also, even as adults, once you get past the juvenile stage, a lot of states have measures in place where you can have these records, completely removed or sealed, depending on the circumstances. So let us jump in to the first question. What is an expunction or expungement, which I answered, and added to that is, how is it different from record sealing? And that is a wonderful question. So this is the thing. When you're dealing with an expunction, it's a complete removal. It's as though it has been erased. It's basically erased. It doesn't exist. No one has access to it. No one. When you talk about sealing a record, or what they refer to here in Texas, a non-disclosure, that means it's sealed. They can't disclose it. Only certain agencies would have access to it. So for a previous client who's done a non-disclosure, that record is sealed. However, there are state and federal agencies who would still have access to the records. For instance, district attorney's office, law enforcement. I tell people, if you're going to be applying for potentially nursing boards, school boards, it's a possibility that they will be able to access those records when you're only having records sealed. Then on the other hand, having an expunction, which completely removes it, everybody destroys the records. So that is a great question for us to have, and it lays the foundation as we continue to move forward. Am I eligible to have my record expunged? Well, that is one. Good evening. My wonderful mother, Miss Ann McCray Reed, has joined us. Welcome, welcome, welcome. Thank you for joining us. Happy to see you. Am I eligible to have my record expunged? Well, this depends. I can't say for certain whether or not, for this particular individual, whether they're qualified or not. We potentially will need to have a consult, but what I will provide some general criteria, if you will, for everybody to be able to assess. Like, look, if I'm in this situation, or if I know someone who's in this situation, they potentially may be eligible for an expunction or an expungement. And let me say, you may hear me like, oh, she's saying it two different ways, because I practice in various jurisdictions, and how they refer to it is different. So I use that interchangeably, just because if we have individuals who may be joining from any of those jurisdictions, one word may resonate with you over the other. But we're referring to the same thing. So say that you were charged with an offense and nothing happened, right? They never brought you up for prosecution. The case just kind of disappeared, for lack of a better term. 9 times out of 10 in that situation, you're going to be eligible. Say that you were actually charged with something. They did indict you, or they moved forward with information, but the case was ultimately dismissed. If you have now, the statute of limitation has passed, you're going to be eligible to have that record to be expunged. There are, for Texas specifically, if you're charged with a Class C, so say that you're charged with a Class C family violence, and say that you do some type of deferred probation on that one. What happens is, once you're done with it, no other instances of arrest or violations of the law come up, that case is going to be dismissed. You're going to be eligible for an expunction on that. When you're dealing with Texas, You need cases to either be dismissed, you need to go to trial and get a not guilty, or it needs to be that Class C level. In those circumstances, you're going to qualify for an expunction. If you are dealing with a Class B and above, and you are put on deferred probation, you are going to qualify for what is referred to as a non-disclosure, which is sealing the record, which means that certain agencies with state and federal would still be able to access those records. All right. And understand, even when it comes down to non-disclosures, there are various criteria that has to be met. So you want to consult with an attorney just so you can make sure that you have everything in place. When it comes down to Mississippi, for instance, there's some statutes where you automatically qualify for a expunction under that particular statute. You have some based on something, it's called non-adjudication. Deferred non-adjudication is the same thing, different states just put a different label on it. In those situations, you potentially qualify for a expunction. Also, there are certain offenses in Mississippi that even if you are convicted of it after a certain amount of time, guess what? You qualify for an expunction. I mean, Mississippi has some advantages for individuals who are dealing with legal matters and want to go back and have their record sealed, and just consult and make sure and just see. If you don't know, you don't know, right? But that's the reason why we do this, so that way you're able to have the information, so that way you're equipped. Okay, so question in the chat: what is the process for applying for an expungement in my jurisdiction? Okay, so for Texas, what the first thing, so you have to file a petition, right? You file a petition with the court for an expunction. And what happens, of course, that documentation, that petition is going to be filed with the court. Then they're going to serve all the respondents, right? Which is, the district attorney's office, the police departments, the Department of Public Safety. All those individuals are going to be served with that petition, and they're going to have an opportunity to respond in regards to your petition, right? And once you file it, as far as, those individuals being served, all that's going to take place with the clerk. Then you're going to have a hearing date that's set. If you're able, typically, when we file those, we file it, we wait the statutory penalty, not penalty, the statutory time for the DA's office to respond. And typically they're responding on behalf of all the other parties, right? If none of them are opposing it or presenting something to say, well, this individual isn't eligible for X, Y, and Z, the district attorney's office will say, hey, we'll file this admission that this person is qualified. Then we're going to process the order and get it over to the judge. If they file a denial, that's evaluated, and then you can actually have it officially set to have a hearing before the court. The thing about it, what's unique about this process and why you just want to kind of make sure that you have all your ducks in a row is because it's specific information that they're looking for in these documents. And you want to ensure that that information is in there so that your records are being, if you qualify and you get an order signed, that your records are being removed. You don't want to go through this whole process and then something was done in error, right? And now it's causing you further delay. What documentation is required to apply? So the only thing that is required besides your petition is typically it's advantageous, if you will. So we're talking about dismissals, right? Because 9 times out of 10, as far as Texas is concerned, that's what's needed for you to be able to, the proof, if you will. You can attach a copy of your dismissal order, right? The order from the judge that the judge has signed to say that that case has been dismissed. In Mississippi, we do the same thing. Your final judgment, because remember, there's different ways or avenues that you can qualify for an expunction in Mississippi. But ultimately with both, what if you decided to do that yourself or your attorney is going to do is ensure that they have that final order, and they're going to attach it as an exhibit to that documentation. What type of charges or convictions can be expunged? Okay, so this is one that I was talking about. And I would say when it comes down to convictions, typically in Texas, sometimes we have to have those tough conversations with individuals, and they call and they say, hey, this is what I was charged with. This is what's going on. Do I qualify? I had a consult with a gentleman a few weeks ago, and he was charged with a DWI. It was a felony, a DWI third offense, and they didn't do deferred or anything, and he had a conviction. And so I had to basically inform him, like, you don't qualify for an expunction in this case because you are convicted. And for anybody in Texas, if you have a conviction, you will not qualify for an expunction nor a non-disclosure. And I say that, and it's noted, and let us share that information because this comes into play. So, sidebar, why is this important to know this? So when individuals are making decisions in regards to when they're charged with an offense, are they going to negotiate? Are they going to work out some type of plea or deal or something of that nature? What should they do? Having that in mind, depending on what your future looks like, what you're anticipating on doing, what position you would like to be in 3, 5, 10 years after you resolve that case is important. Because if, like I say, if you have a conviction, guess what? That is going to be on your record. There are some exceptions, as I stated, for individuals who are in Mississippi. And in that situation, it's best for you to just reach out to counsel. Let us know what you have been charged with, and then we can go and make sure it's not one of those offenses which are on the list that says you don't qualify. And typically it's like crimes of moral turpitude. You're dealing with like embezzlement and things of that nature. They have listed as convictions that are not eligible if it is a conviction. And so other than that, if you, like I say, if you're charged with something and it's eventually dismissed, it doesn't matter what the charge is. Let me be careful with that. Let me come back. Okay, so you have instances where people are charged with, so say for instance, if you're charged with sexual assault of a child and that case is dismissed, based on our initial conversation, your mind is going to say, oh, well, guess what? I qualify for an expunction. The thing is, the second part of that, remember I mentioned that the statute of limitation has also passed. The time has run for them to be able to charge you. Well, when you're dealing with offenses such as that, there's no statute of limitation. So guess what? It stays on your record unless you can prove some other elements. So in these situations, 9 times out of 10, when you file a petition, the state is going to object. Then you're going to have a hearing to put on evidence showing, like, look, there wasn't any probable cause, right? And that's a whole nother discussion, in-depth discussion to have with an attorney to help you navigate that. And I will tell you why this is also important, because remember when I say about making decisions early on, they can impact you in the future. I had an individual who reached out to our office about trying to obtain an expunction because there were charges brought years ago for sexual assault of a child. Well, guess what? The day of the trial, the cases were dismissed. Wonderful news, right? That's great news. Those type of charges, those are serious charges. They're dismissed. Who wouldn't want that? An individual who is now 7 years removed trying to get employment, and it's showing up on the arrest is showing up on his background, and it's showing up that the case is dismissed, but it's like a scarlet letter. So unfortunately, it has been causing him issues with certain individuals, certain employers not wanting to hire him. And so there are ways to navigate that when you appear in court and then the state is just saying, hey, we just want to go ahead and dismiss it. If you're dealing with charges that do not have statute of limitations, that is a conversation that you want to ensure that you're having with your attorney, because you could run into issues later down the line. How long do I need to wait after the completion of my sentence before applying? So say, for instance, we're talking about the Class C, right? So when you're dealing with the Class C, 9 times out of 10, when you do a deferred on that, it's like 3 months. 3 months, you're not reporting to anybody, but it's just in that amount of time, don't get in any trouble, don't have any issues, the case is going to be dismissed. Once that case is dismissed, typically from the filing to that point, you run your statute of limitations, you can file immediately. When you're dealing with non-disclosures, it's different, right? And all of these you're dealing with So let's give a DWI example. So individual is charged with a DWI, they're doing non-deferred. Well, if they have an interlock device in their vehicle, once the case is dismissed, they completed probation, and they had that device, they're able to file for a non-disclosure, a sealing of the record within 2 years. If they don't have the device, it's 5 years. Typically on all felony offenses, if you're doing non-deferred, once the case is dismissed, you'll be able to qualify for a non-disclosure within 5 years. If it is misdemeanor offenses, it's typically I filed some soon as the statute of limitations has passed to have those records sealed. But that's the gist of it. Like I said, you do have those unique caveats when it comes down to the DWI cases. What's one common myth or misunderstanding people have about an expungement? It's going to be the one that I mentioned. If people, and I guess this is more of a Texas specific situation, when you're going and you're pleading to something and it's based on a deferred probation sentence, and you hear like, oh, your case is going to be dismissed when it's all said and done. And so the fact that you hear dismissal, you think that it's automatically going to have you eligible for an expunction, and it's not. And so you have to be mindful of that. And then the process, it varies. In Mississippi, I had it where we could file these petitions. We go present it to the state. State, are you opposed? You're not opposed to it? Okay, let me take my order over here to the judge within the same day, within the same week. Judge signs off on it. I send it to the clerk. Hey, tell my client, give it 30 to 60 days to let that order be sent out to everybody it needs to ensure these records are going to be removed, and then you'll be in good standing. In Texas, I tell people give 3 to 6 months, and this is with everything going the way that it should go. Sometimes there are things that happen that are out of our control, as far as what we control, and that's what, whether with the clerk's office, the DA's office, whatever the case it may be. Sometimes there's additional delay, but when you think about the time frame, we tell individuals it takes about 3 to 6 months. Sometimes we're able to get some done faster than that, which is always great. But we try to provide realistic time frames, and also just let people know, like from experience, we have things that come, it happens, right? And it's out of our control, but we're going to do everything that we can to make sure that it gets done. But delays and things happen. They truly do. But that's a part of life as well. Things happen. Does my entire criminal record go away if I can get an expunction? Well, the only thing that's going to go away is the particular offense that is eligible for that expunction, right? So it's not as though you go and you file an expunction and it's like a blanket overall, whatever is on my criminal record is removed, right? You have to be specific and detailing what you're applying to be expunged in that petition to the courts. So it's not a blanket coverall type of thing. Now, can you list multiple offenses in your petition? Yes, you can. And that's what you will have to do. But it's not just like, oh, I filed this petition and it's just like clear my record. That's not what it is. You have to be specific in detail about what you're requesting the court to order to actually be removed. Okay, and then there was a question: how long does it take to process? And that's what I just mentioned for everybody. Do I need an attorney to file for an expungement? Well, no, you do not. Most states have allowed individuals to proceed pro se, right? That means you can do it by yourself. What I tell people is, even in proceeding pro se, you want to make sure that you have information. Sometimes just because you can do it by yourself doesn't mean that you should, right? And in various areas of the law, I've seen people attempt to proceed to do things on their own. It's not a problem, but I've seen individuals run into instances and it puts them in a bad position, or they still end up having to go back and rectify some things, or they have situations where they have to get individuals to come in and, assist them and go back. And potentially in those situations, people were maybe trying to save money and things of that nature. but it doesn't benefit them in the end because it's just more time that they're exerting, and then they still have to go out and get someone to assist them. And what I tell people, even if it's you just making a phone call and scheduling a consult to have the conversation just to make sure that what you're doing is in line and is correct, you may want to present it that way. So pay the small portion for the consult fee, just so that way you're informed and you're doing it accordingly. That's ultimately what it is. You don't want to screw it up, right? And when it comes down to costs associated with expunctions, most courts, whether expunction or having your record sealed, there's going to be a filing fee with the court, right? If you have to file them in the district court, felony courts, there's going to be a higher fee. If you're filing them on Class C misdemeanors that are in the municipal courts, the fee there is going to be less than what it is. But there is a filing fee that is associated with it. And that's regardless of whether you have an attorney or not. Would I be required to disclose expunged records on job applications or other legal documents? No. So that is the one benefit. And why why this information is important, right? Because if you were charged with something and the court has ordered for that record to be sealed, you can truthfully answer when they ask you that question on that job application. Have you ever been charged or, convicted or anything, charged, arrested, or convicted of any type of crime? You can say no, legally. And I think it's another question that I seen when I was just, getting prepared for today. That I want to mention based on this question is that will they show up on my background checks? Well, that's the ultimate purpose of having an expunction, right? So it doesn't show up. However, every blue moon, you'll have an individual who is saying, look, I had this record expunged, but it's showing up on my record. Always, if anybody's in a situation where you get an expunction, you get a record sealed, your attorney is going to provide you with a copy of that signed order. Keep a copy. I don't care how long it is. Keep a copy. I'll give you, I'll share a story with you, an example, if you will. I had a client reach out, and I think this was last year. He had already paid to have a matter expunged, right? Well, for whatever reason, months later, not even months, years later, it was still showing up. It was showing up on a background check. Thing is, he didn't have a copy of it to be able to go and just submit it to the clerk or whoever to, do some things to get that record removed. He had to go through the entire process all over again. So you keep those records. Also, if things happen to show up and they come back, not only for you to be able to address it and get them removed, but also so you're not potentially falling into bad term or being on bad terms with that employer or whoever who has been able to locate that record, because you can show them, look, I legally have a right to tell you that no, I wasn't charged with this offense. Can someone oppose my application? Yes, they can. You can have the district attorney's office oppose it, which is the state. The state can oppose it. DPS can oppose it, which of course they're a part of the state as well, basically. So yes, the state can oppose it. And then what happens is that you would have to have a hearing to put the evidence before the judge in regards to your eligibility for that expunction and whether or not the court is actually going to grant it. Can expungement help me get a job or housing? Definitely. I would say it definitely can. And why do I say that and say it with such confidence? Because I've encountered so many individuals where they are denied housing or employment simply because they have an offense on their record and they're not even if they're not even convicted of it. I think I discussed this on a previous live that we did, how just charges alone have impact on individuals when it comes to employment and when it comes to housing. So yes, having it removed is important. And some people have things on there and they don't worry about it because it doesn't have an impact. Some people it will. So this is why you need to know this information. If you have been charged with something and nothing came about it, inquire about if it's charges for which you can have removed from your record. Have I seen that happen? Yes, I have. And I've seen this happen in the case where I gave the example about the sexual assault, right? Well, the state opposed the petition saying, look, the statute of limitations has not passed on this, right? And they also came from they're going to come and try to refute our position also in regards to probable cause, that there was no probable cause either when they indicted it or at the time that it was dismissed. And so we had to have a hearing and evidence is presented to the judge. And a caveat with that is understanding, and now, is it likely to happen? No. But the thing is in these hearings, 9 times out of 10, the petitioner, which would be anybody, the person who's actually filing for that record to be removed, they're going to be testifying at that hearing. Well, if the statute of limitations has not passed, there is the concern of you making statements that could potentially be used against you later on, right? And so, it's one of those double-edged swords that you have to be careful about. Discussions need to be made with your attorney when you're dealing with those cases that do not have a statute of limitation. And there are some additional caveats too, like partial expunctions and things of that nature after a certain time period. But these are, kind of when you get into those case by case nitty-gritty details that require a little bit additional evaluation and consideration about what steps may be out there and what options are available to you. But yes, I've definitely seen it happen. And it doesn't happen as often. I would say in the past 3 years, I've had 1, 2, 3. I've had 3 applications out of over 100 that have been opposed for one reason or another. And one is when it deals with, so understanding too, when it comes down to non-disclosures, sometimes those are not automatic, right? You have, depending on the certain statute, it's not automatic. Some is it in the best interest, right? And I had an individual, he had pled down, but he had some previous history. And the state opposed it, was like, look, this is not in the best interest. This individual has previous assault. This is what was alleged. And, this is what they actually pled to. But all these different concerns that they raised. And you can find yourself in a situation where the judge is saying, okay, yeah, you're requesting this, but it's not in the best interest to grant it. So, but that's the reason, of course, to have the conversations, to have a game plan together. And those are more so situations too where I don't recommend individuals trying to do it yourself. Can you do it? You surely can, but understand that things can come up, and you will want to have counsel who is knowledgeable and who has seen that to be able to formulate the right arguments and present everything accordingly for you. Now, that doesn't mean it's a guarantee. No attorney, let me say this, and no attorney can guarantee you anything. If they do, I will tell you to be very careful. But as an attorney, we should not be making guarantees. We should not be making promises, because even in the best case scenario, when you think everything should go this particular way, anything can happen, And if you know any attorney, they will probably tell you even when it comes to trial, there's been attorneys who they had the best case. You would think there's no way they can go in there and lose, and they can lose. You go in there and the case looks terrible. There's no way they can win. And they win. This is why we don't make guarantees and we don't make promises, regardless of what it is. And so I have a question here about, can convictions be expunged? If you're dealing with clemency, you're dealing with pardons, right? So if you get a pardon from the government, they go back and they say, look, convictions overturned. In those situations, yes. But just just ultimately convictions, besides kind of the exceptions that Mississippi have, for the most part, no, you're not going to qualify. You're not going to qualify, unfortunately. Next question was about juvenile records. I did address that one already, that juvenile records can be expunged. What happens if my expungement request is denied? Well, unless it's a limited circumstances where you can actually try to appeal it, it's denied. It's denied. There are certain circumstances where you can appeal the court's denial and take it up to the higher court and present your evidence to them. And the higher court can make a determination of whether or not, the court abuses discretions or things of that nature and make a decision there. Can I have multiple charges or just one expunged? You can have multiple. We've definitely filed petitions where there's multiple charges that we include in there. It depends on the circumstances. But yes, it doesn't have to just be one. There are multiples that have that can be listed in one petition. Okay, so I have answered all the questions that were previously submitted. Not bad timing. I mean, we're doing good. But I say that just to say, if you all have some additional questions, you can put them in there. I mean, for the most part, dealing with expunctions and non-disclosures are kind of straightforward. There are some caveats here and there, but I will say, like I say, for some individuals dealing with unique circumstances, if you have prior offenses, things of that nature, you do want to inquire about it. These are things to think about early on if you're charged with an offense too, because you're thinking like, look what I. So let me give you this example, because remember we talked about dismissals. So say if you're charged with unlawful carrying of a weapon, or if you're charged with assault family violence, misdemeanor cases, right? If you do a conditional dismissal, if you do some type of pretrial program, well, guess what? Once in those programs, what's going to happen is when it's done, it's going to be dismissed. And guess what? And those, you never went before the judge, you never entered a plea, you're not on probation or anything of that nature. And so you are going to be eligible for an expunction once the statute of limitations has passed. So sometimes, we're doing these Wise Counsel Wednesdays and we're breaking different aspects of various areas down, right? And sometimes what happens is when you put it all together, it begins to make sense. If you're dealing with an attorney, they're like, well, look, I'm going to potentially negotiate X, Y, and Z for you. Or this is what they have presented to you, but this is why you need, these are the pros and cons of you taking this action or accepting this offer. Because what you can potentially or potentially not be able to do down the future comes into play. And this is also why you want to have counsel who is aware and knowledgeable of these things, because it better situates you. And this is why we also are concerned about the person, right? It's beyond more than just your charge. Because say, for instance, I have an individual who's 18. They're like, hey, Mrs. Stewart, I know I'm charged with this. This is the first time I've been in trouble. I'm really considering going to the military. I'm a veteran myself. I understand. Look, you don't want to have a criminal record. You want everything to be as straightforward as possible. So with that in mind, now I'm able to better advocate because I know my client's goals and aspirations and what they're trying to do, right? It's not just, oh, you have this charge, let's get it disposed for you. Let's get a resolution to it. No, what does your future look like? What are you trying to do? And that's in every situation. There's individuals who have felony drug possession charges, right? There's options out there. Maybe we need to be trying to see if we can get you, for instance, in Mississippi, a drug court program. Here in Texas, some type of pretrial program. Let us see. Tell me about yourself. Tell me what's going on. What are you trying to do within the next few years? What does your future look like? Those things matter, right? And so these are things that you need to take into consideration, even when you're out there and you're having consults and you're considering hiring any attorney for various situations. Be mindful of those type of things, okay? And so I'm gonna put this QR code up for you all to scan. You have all of our information. Also, the banner has been going down at the bottom of the page. If you aren't already, follow us on all our social media platforms. We're on Facebook, we're on Instagram, we're on YouTube. Follow us on LinkedIn, because we're always putting out information, wanting to equip our people, because knowledge is power. You know, knowledge is power, and the knowledge that you have is going to better suit you. And guess what? Even if it's something that you don't necessarily need, you could be able to assist someone else with the information that they need in circumstances, or be able to recommend to them how they can go and who they need to contact to have their questions answered. So knowledge is power, and we're trying to share. So make sure you're following us so you don't miss different updates and things that may be going on in the future, because we're going to have some things coming out that we will provide at a later date. One thing that I do want to go ahead and share with you all now is the Attract Abundance Conference is coming up. I will be speaking at this conference October 24th through the 26th. It's going to be an amazing conference. It's about building wealth, right? Building wealth not only for yourself, but for the generations to come. You know, building up something for your children's children's children. If you use my discount code Christian10, you will get a discount on your tickets. Early bird tickets are on sale now. So go ahead, scan it, get your ticket, get signed up. Okay. Also, if you have not signed up for our newsletter, a link is going to be placed in the chat. It's already there. Go and hit that link to get signed up for the newsletter. We send out just useful information. We are not going to spam your inbox. I promise you. I know we all get enough. We all get enough emails already. We send out one email a month just to provide you with some insights, some knowledgeable information. That way you can have it. All right. Okay. So with that, another amazing time to come and join you all this evening to answer your questions. And if you end up coming back and you're watching this as a replay, hit replay in the chat just so we can know, and you can send us questions, topics, all those different things. You do not have to wait until Wednesday. Jump in the DM or send it here in the chat. Make a comment about it. We're more than happy. And of course, we want to come and present topics that are going to be beneficial to you all. Topics that you all are interested in. So look, you tell us, and then we're going to come and bring the information. But it's such a pleasure to always come and to join you. Y'all reach out to us. That's what we're here for. McCray Stewart and Associates, your trusted advocates for justice and peace of mind. With that being said, you all have a wonderful evening, and we're going to see you back here next Wednesday. Good evening, everyone.